The Arizona fake electors case moves forward with not guilty pleas entered by 11 defendants, and the criminal trial against Donald Trump for falsifying business records moves to its final phase. Here now for insight into these two high-profile cases is former U.S. Attorney Paul Charlton, a partner at Dentons. Good to see you again. Thanks for joining us.
Thanks for having me, Ted.
Got a lot to talk about here. This fake electors case, we got 11 defendants. They all plead not guilty, forgery and fraudulent schemes. What'd you make of what happened yesterday?
Well, it's standard fare for criminal cases that take place every day in courtrooms all across the country. What makes it different is that the State Attorney General's office is contending that these individuals and their co-conspirators were attempting to alter the lawful election, that they were putting our republic at risk. It is a very serious allegation, and while the charges are felonies, and those are by themselves serious, the underlying accusations are even more serious, and the Attorney General says poses a risk to our democracy.
And Rudy Giuliani, this was interesting. He has to appear within $10,000 secured bond. First of all, how does that work? And is that unusual?
It would be very unusual if we were to discuss this a few years ago and say a former U.S. attorney from the Southern District of New York was going to have to post a $10,000 bond on felony charges. That is unusual. Posting a bond when you're attempting to evade service of process, as the Attorney General alleges occurred here. They say they tried to serve Mr. Giuliani a number of times with his summons, and he declined to make himself available. This is what the court does when you are a risk of not appearing in the future. And so this is an attempt to ensure that he'll be here when he has to be.
And he was the only one of the defendants with that bond, which suggests he was the only one of the defendants who was out there bobbing and weaving around service.
In typical white-collar cases, you'll find most white-collar defendants, through their lawyers, will accept service. They'll guarantee or promise the court that their clients will appear. And it's a really very informal, almost polite process. But he changed that by making it difficult for the Attorney General's office to serve him.
He also, some of his quotes, "I've shown no tendency not to comply. I show up at every court appearance." But at one time, he wouldn't stop talking. And the court commissioner threatened to turn off his mic. So there seems to be a disconnect between, it sounds like he simply doesn't take these things. He's been around a long time. Why isn't he taking this seriously?
He certainly knows better. He is, as we said, a very experienced former prosecutor. But when he speaks like that to a judge, it's not for her consumption. You could hear as you listened to her that she was losing patience with him. Mm-hmm. The audience to whom somebody like Rudy Giuliani is addressing these comments is not the judge, it's not the court, it won't be a future jury, it's the MAGA supporters or the audience of one former President Trump. So that's who it is he's trying to address, that's who it is he's trying to woo, but it's not an effective tactic for a lawyer who's appearing before a judge for the first time.
Set to go to trial sometime in October. Is that likely to be pushed out, do you think?
I'd say slim to none are the possibilities that this trial will take place even before the election.
Yeah.
These white-collar cases, if they are ever tried, if they are ever brought to a jury, if they can do that within a year, that's moving at light speed. I expect with this many defendants and on the kind of complexities that we see reflected in this 58-page indictment, we probably won't see this done within a year, maybe a year and a half. It could even go beyond that.
That's really pushed out. As far as the defense is concerned, what's the argument here? It can't be ignorance. I didn't know what I was doing. What are we hearing?
Well, there are at least four lawyers who are charged inside this indictment. And I suspect that those individuals who are not lawyers are going to say, we were advised by lawyers that what we were doing by claiming to be electors when we weren't electors was lawful, and therefore we didn't have the intent to violate the law. The lawyers, on the other hand, are going to have a much more difficult argument to make, and we'll have to see what their defense is going to be.
What about a First Amendment defense?
In other words, that they said, we don't believe the election was fair. That's fine, but what they did was, according to the Attorney General's office, was submit formal documents which said we are the lawful electors for the state of Arizona, and the Attorney General alleges that they did so because they had a hope then Vice President Pence would ignore the lawful electors who had been approved by then Republican Governor Ducey and who were going to vote for President Biden, ignore that, choose the Trump electors, and overturn the election. That the Attorney General says is what this conspiracy was all about, to change the lawful election.
And contingency, though, was not mentioned at all by this group. I think it was mentioned by the New Mexico group, but not by this group.
It's a very good and an important point. In Pennsylvania, that state said, we aren't going to hold ourselves out to be electors unless a court says the election was fraudulent. And here in Arizona, that contingency wasn't put into their documents.
Last question. Plea deals, cooperation, you expecting to see some of that?
I think it has to happen here in the sense that if the government wants to be successful, they're going to have to look for people who are cooperating. And you can even get hints of it. There are a number of people who are unindicted co-conspirators. I suspect that's a bit of a obvious code. These are people who are already cooperating with us and providing us with information.
Interesting. All right, the Trump trial moving to its final phase. What, jury comes back Tuesday?
Correct.
All right, so what do you make of what has happened so far?
It's been fascinating to watch because what you are hearing, and it's unfortunate we don't get to hear this directly, that we don't get to see this on television in the way that some courts will allow you to do. But what we are hearing is that this prosecution has presented a case, much like you might think about any other drug case or any other case in which there are let's just say, people who are difficult, people like a former porn star as a witness would be a difficult witness to put forward if you were the government, people who have been convicted of perjury. What the government had to do was construct a case in which corroboration supported the evidence that Trump, former President Trump, committed a number of crimes relating to false business records in order to hide another crime relating to election fraud, and that becomes a number of felonies. So all of that done artfully, I would say, by the prosecution, but they still live with the difficulty of difficult witnesses.
And they live with the idea that you've got to convince the jury, and thus we have jury instructions, and even that became a problem here. What was that all about?
So jury instructions are typically composed of two different parts. One are the standard jury instructions. Here's your obligation as a juror. Here's what proof beyond a reasonable doubt means. But as to the law here, as we were just describing it, there are a number of specific steps that these jurors are going to have to think about and follow, and there are various views. Obviously, the defense has one view that is much more favorable to former President Trump, and the prosecution has another view which would be much more favorable to their case. So, for example, the defense says, Mr. Cohen, who testified against former President Trump, Mr. Cohen deleted some of his emails and texts. We want you, Judge, to instruct the jury that that deletion can mean, and they should infer, that he was trying to hide something that would have been bad for him. That's the kind of jury instruction they're asking for. It's the kind of jury instruction the government, the prosecution is objecting to. We'll have to see what the judge decides.
You can get really in the weeds with that stuff, can't you?
You're taking law school, kind of high caliber, difficult legal issues, and trying to explain them to a lay juror.
Donald Trump did not take the stand in his own defense. Do you think that was wise?
So it's very interesting, isn't it? Because former President Trump has the same rights that we all have. The right to remain silent in the face of a government accusation. And the jury cannot take any adverse inference. And they'll be instructed on that when it comes to jury instructions. But he has multiple times said, I am going to testify. I want to tell the truth. And Ted, what's important to remember too is the defendant in every criminal case has the right to say, no, I won't testify, but he also has the right, even over his attorney's advice, to say, I insist, I want to testify. That didn't happen here. We'll have to see how that plays out before the jury.
Speaker Mike Johnson called, and a lot of Republicans on Capitol Hill have gone up to New York, and they've sat and they've shown support and they've spoken afterwards. Calls the trial corrupt and a sham. What is all of this doing to the legal system in America?
Well, I think it's unfortunate that people who have a following, like the congressmen who are appearing before the former acting attorney general, Matt Whitaker, was there, and who are accusing this trial, this judge, these prosecutors of creating a sham prosecution. One of the great sort of cornerstones of our criminal justice system, and what it is that I think makes it the greatest criminal justice system in the world, is the jury system. If this is a sham, if this is a prosecution that ought not to have been brought, then the jurors will tell the prosecution that when they render their verdict. If it wasn't a sham, if it was something that former President Trump did and he deserves a felony conviction, the jurors will render that kind of verdict. That's the way our system of justice works. It works for you and me the very same way it should work for former presidents.
Paul Charlton, Denton's great conversation, great analysis.